We are ready to conclude material in Chapter 5. This is Part 3 of the 3 PowerPoints on Chapter 5. In this particular one, we're going to continue looking at procedural law, but instead of concentrating simply on adversarial and inquisitorial aspects, we're going to see how Islamic law and the Eastern Asia legal tradition present variations of the adversarial and inquisitorial models. They don't fit neatly into either one of those. Islamic law is considered to be a mixed process. The penalties for any criminal acts under Islamic law are prescribed, as we know, in the Quran and the Sunnah, but the procedures that are used to apprehend and adjudicate the offenders are oftentimes left to the state's discretion. They weren't well defined or described in either the Quran or the Sunnah. And so the authorities needed to come up with the actual procedures to be used. The end result is some adversarial aspects. For example, under Islamic law, defendants have the right to confront their accusers and to maintain their silence. They also have a modified presumption of innocence. We'll see more what that means in a few moments. There's also some inquisitorial aspects under Islamic law. There's little division between the judge and the investigator, and defense attorney role is less of confrontational, as you would find in the adversarial system, and much more one of just presenting favorable evidence to the court for preparation for sentencing, for example. As we look at these, the procedural law under Islamic tradition is first of all administered in what is referred to as the Qadi's court. It's Q-A-D-I. And the Qadi is the equivalent to a judge in other court systems. The accused is presumed innocent until proved guilty under Islamic law. And the burden of proof lies not with the state so much as with the accuser. We've talked earlier about how under the Islamic tradition the victim is seen as having much more of a role to play, and it's the victim's rights that were violated more so than a crime in the sense of all of society being harmed or wronged. When doubt exists regarding the accused's involvement in the act, resolution is in favor of the defendant, and convictions are based upon the assertion of uncertainty of 3 forms of evidence, and those 3 forms of evidence are testimony, confession, and religious oath. And we're going to take a look at each of those forms of evidence more closely. Taking testimony, first of all, by tradition, truth is found under the Islamic system through the statements that are made by reliable people. Islam is essentially handed down from generation to generation. And from the statements in the Sunnah regarding how Muhammad had led his life, from initially those individuals who were living and being with Muhammad at the time. Those statements and actions are true because they were reported to be true by reliable men from generation to generation. And so you go back in talking about this is what Muhammad said because so-and-so said he said it, and he heard it from so-and-so, and that person heard it from so-and-so. And you identify each generation of reliable men that were passing along this information. And that is important because as we talk about the testimony in the Islamic system, all testimony from reliable people is given a considerable amount of weight. And not just because that's the way the court system operates, but instead because that's the way Islam itself feels and thinks about testimony, oral testimony. It's given a great deal of credence. The accuser shows their truthfulness of complaint by having witnesses give testimony on his or her behalf. So if you're accusing someone of having committed a crime against you or your property, then the truthfulness of your complaint is relayed by testimony on your behalf. Witnesses, who oftentimes are described as needing to be male adults of high moral character, are asked to testify directly about their personal knowledge of the truth. The number of witnesses and sometimes the gender will vary by Qadi's court and or by Islamic school of justice. The example given here is adultery requires 4 witnesses. If it's theft, only 2 witnesses are needed. In a few cases, you'll find the testimony of a woman being accepted. Sometimes it's stated as the testimony of 2 women are needed to come to the level of the testimony of 1 reliable male. So these kind of things will again vary depending upon which particular Islamic law judicial system we're looking at, or school of law, I should say, that we're looking at. Religious oaths. It's not always possible, as you can well imagine, to produce the required number of witnesses. Oftentimes the Qadi is left with only partial evidence upon which he has to make a decision. When that happens, it's not unusual to return or ask for an oath to be taken. Either side, the accuser or the defendant, can actually ask or request that the other take an oath, but the court is the one who prepares the oath. And so the way that the judge has phrased it will actually give give one side or the other the advantage. You could phrase, if you're the judge, you could ask the person to take an oath that what, as the accuser, he has stated is the truth, or you could ask the defendant to take an oath regarding the falseness of what the accuser had said, as opposed to taking an oath that what you as the defendant has said is the truth. So the way that the oath is phrased can play a big role in how one responds to that. The options that are included are taking an oath. You could decline to take an oath, or you could require an adversary to take an oath. So if you are asked to take the oath, you could say, I refuse to do so, but I want my adversary, I want the person who's accusing me to take the oath instead. The case is decided, as I said earlier, based upon how the oath is phrased and who is asked to give it. So in this way, the Qadi has a good bit of influence over how this case will end up. And it's also important to understand that giving an oath under Islamic law is a much more serious kind of action than it might be under other systems, religious systems or political systems, anything else. It's, the giving of an oath is seen as being very, very important, and could have, for those who lied under oath or gave a false oath, could have dramatically negative effects in the afterlife, were you to have falsely swore. A confession is also an acceptable type of testimony. This is considered to be given when the accused voluntarily admits to the charges. It can only be admitted, however, when the confessor is said to be a mature and capable individual who is able to understand the consequences of his or her utterances. The confession has to be completely voluntary, it has to be very explicit, and it has to be clear. And if those conditions are met, then the confession can be accepted by the court. And it would be accepted as an indication of guilt. The defendant is convicted when the Qadi deems guilt is clear and explicit, or stated differently, when the evidence is conclusive. They don't use a phrase like we would, the beyond a reasonable doubt, for example, but the idea of clear and explicit and conclusive evidence is seen as having a similar kind of meaning to beyond a reasonable doubt. Under the Eastern Asia legal tradition, you recall that this legal tradition is identified most clearly by its reliance on both formal and informal aspects. And this is true not only of the substantive law that we've already talked about, but also of procedural law. Under formal procedural law, the procedures are seen as showing both a mixture of inquisitorial and adversarial aspects. Japan's quasi-jury system, which is talked about in greater detail in Chapter 10, is an example of this. You have certain aspects of adversarial system, but there's also access to and a very active, in many ways, defense counsel that seems much more like the inquisitorial defense counsel in the sense of saying good things about the defendant, making sure that positive background is brought up, and not so much a challenging role, not in the sense of an adversarial response to the accusations. Under the informal procedural law, the informal procedures are said to reflect a preference on legal informalism. And you'll recall that when we were talking about substantive law, we made reference to vagueness and the way that the law is written. It's flexible enough so that suspects can be responded to in an informal manner by the police, by the prosecutors, and so on. And as a result, we have what ends up being a rather different system than either inquisitorial or adversarial systems, relying more upon this flexibility, if you will, or in some ways even vagueness in having the process going forward. It would look both to the Japanese trial, for example, would look to both the inquisitorial and adversarial attorneys as being a very, very informal by their standards procedure by which the individuals are being brought forward to trial. We return to these aspects of the inquisitorial process again in Chapter 7, so we'll come back to several of those. But what we've just covered gives you an idea anyway. I'd ask that you keep in mind that the inquisitorial process described here is the version most typical of the European countries. Many European countries have been adding some adversarial aspects to the process, for example, a formal presentation of evidence, a chance for everyone to ask questions of the witnesses rather than just having the judge ask the questions. And those are seen as being movements by many of the European countries toward a more adversarial aspect. We don't see a similar thing occurring, at least in criminal law, in common law systems like the United States. There isn't, as I suggest, a movement toward greater use of, in the inquisitorial process anyway. I refer you to the reading on the frustrated turn to adversarial process in Italy that you'll find in Module 7. It gives you a good overview of how the adversarial process is being implemented, or at least trying to be implemented under the Italian system. Judicial review ends this chapter. It is the second major topic under procedural law. Here's where we talk primarily about the rule of law, and the rule of law is said to be accomplished through judicial review. The importance of the concept requires us to briefly look at it. This is another chart from your textbook showing the steps to achieving the rule of law. The basic question is whether or not a country views its law or its government as supreme. When the answer is the law is seen as supreme, then the country is said to have achieved a rule of law. And this is based upon, starting at the very bottom on the left, the supremacy of certain fundamental values being recognized. So, for example, using the United States, the Constitution is written and the Bill of Rights is presented. And the Bill of Rights itself, and of course other places as well, identifies certain fundamental values. The next step up, those values are reduced to written form so that they can be easily understood and distributed to all concerned. And then finally, substantive and administrative procedures are established to make sure that the government agents are following those fundamental principles, or allowing those principles to be actually fulfilled. And once those three steps are achieved, then a particular country is said to be following the rule of law. Now, one of the ways that we can go about assuring that a country does that is what is referred to as judicial review. This is the process by which governments are held accountable to the law. Your textbook identifies three different ways in which judicial review can be carried out: the diffuse, concentrated, and mixed systems. Under the diffuse system, the entire judiciary has the duty of constitutional control, and they do this by following precedent, or some structural equivalent to precedent. This, of course, is what we have in the United States, so that courts at all levels, everywhere in the country, can make a determination as to whether or not a particular law violates not only just state constitutions, but even United States constitutions. We've seen this most recently, or at least in Colorado we have, in the marriage acts with some of the U.S. district courts, but also even some of the local state level courts ruling against, in Colorado's instance, the laws banning same-sex marriage. Now, when the law is reviewed and said to be violating the Constitution, this is an example of the diffuse judicial review models. That is, again, of course, at every level can make these determinations. Now, eventually, of course, the final decision is made by the United States Supreme Court, and that's where we get the final say. The ruling by the state courts or even the United States district courts are not necessarily final unless, of course, the Supreme Court refuses to hear a decision made by a lower court, and then it stands in that sense. But generally speaking, we would say that the Supreme Court is the one that would have the final say, but all the other courts get the ball rolling, as it were. Under the concentrated model, specific government entity rules on constitutionality of laws. And you see this in many countries where there is a constitutional court, for example, that is established. And then questions of a constitutional nature go not to the trial courts that we would think of them in the United States, but instead to a very specific court tasked only with determining the constitutionality of a law or of a decision. Under a mixed system, there's a specific government body that reviews the constitutionality of laws, but all of the courts have the power to ignore laws they deem unconstitutional. So you have a mixture of, in a sense, the diffuse and the concentrated models, in the sense that the courts throughout the country can deem a law to be unconstitutional, but eventually a specific government entity will make a review of the constitutionality and will make a ruling that everybody else has to abide by. That completes our review of Chapter 5. I appreciate your attention, and we will be moving on to Chapter 6 in the next PowerPoint. Thank you.